Good day to you. I hope that you're all rested and happy and healthy and well and wise. Uh, we're here uh, this time to do the second lecture in our sequence of lectures on the President and the Constitution. In this lecture, we will talk about the Constitutional Convention, the day-to-day proceedings of the Constitutional Convention, the various plans that were put forward for the new government as well as the presidency. We will talk about the attitudes of the framers toward democracy. And then finally, we will summarize the eventual outcome of the Constitutional Convention. The convention lasted from early May up to August. And at the convention, we find the actual framework is laid out for the American presidency. So without further ado, I will go ahead and share the screen with our lecture notes. Okay, again, this is the presidency and the Constitution, part 2. Okay, so at the Constitutional Convention, the deliberations were kept secret. Why were they kept secret? Well, there was a belief that if they were open to the public, that nothing would get done and chaos would emerge if they were not kept secret. So they were kept secret from the general public. Nevertheless, we have a historical record of what happened at the Constitutional Convention. A lot of what we know about the deliberations at the Constitutional Convention comes from James Madison's day-by-day notes taken during the Constitutional Convention. A really nice resource on the Constitutional Convention can be found at this link. We'll go there in a second. Here you're going to find Madison's notes, as well as a whole lot of other materials, including letters and correspondences between the participants at the convention, summaries of activities, and so forth. Again, this is a really nice resource on what happened at the Constitutional Convention. Let's go there. And so we have a nice description of the convention itself. I encourage you to go through these materials on your own. So let's go back to our lecture and proceed forward. There were 73 delegates who were appointed by the state legislatures to the Constitutional Convention. Of those 73 delegates who were appointed, only 55 attended. Of that 55, the final document was signed by only 39 of the participants. Those who were appointed but not attending smelled a rat, as Patrick Henry put it. Those attending but not signing disagreed with the final product and went home to lobby against the final document. Okay, a really important point here. Most of the delegates to the Constitutional Convention literally hated the idea of democracy. It was not like democracy is thought of now, where we view democracy as a very positive thing. All the delegates had to go on was the history prior to the Constitutional Convention. And every democracy that had existed prior to the Constitutional Convention had failed, ended up in chaos, as the Athenians had done. And so most of the delegates really disliked the idea of democracy. At the Constitutional Convention, there was a notable absence of leading figures that would surely have favored greater popular democracy. In particular, Thomas Jefferson was absent, Thomas Paine, Samuel Adams, and Patrick Henry, all of whom favored more representation for the common man. Jefferson was serving as ambassador to France. Thomas Paine had returned to Europe after the American Revolution, where he was instrumental in fomenting the French Revolution. Samuel Adams and Patrick Henry both declined invitations, believing the purpose of the convention was to trample on Americans' rights. However, there were a few voices at the Constitutional Convention who favored greater popular democracy. Benjamin Franklin said, and this is taken directly from Madison's notes on August the 7th, "It is of great consequence that we should not depress the virtue and public spirit of the common people, of which they displayed a great deal during the war, and which contributed principally to the favorable issue of it." So Franklin did not think that the delegates really had a right to narrow the privileges of the electorate. Let's go to this page out of the notes that Madison took so you can get a flavor of what Madison was doing. Okay, so you can see here the page starts on August the 7th. The report of the Committee of Detail was being taken up. This is a committee that is authorized to finalize the Constitution. Mr. Pinckney moved that it be referred to a committee of the whole, that is all the delegates. This was strongly opposed by Mr. Gorham and several others as likely to produce unnecessary delay, and was negatived. Delaware, Maryland, and Virginia only being in the affirmative. The preamble of the report was agreed on. Article 3 was being considered. Colonel Mason doubted the propriety of giving each branch a negative on the other in all cases. There were some cases in which it was, he supposed, not intended to be given, as in the case of balloting for appointments. Governor Morris moved to insert legislative acts instead of all cases. Mr. Williamson seconds him on that motion. So you can see Madison's notes here are quite detailed in recording the positions of every delegate who is participating in an activity on the day's proceedings. Okay, so I've given you a little flavor of Madison's notes. Let's exit that and go back to our lecture. So again, Franklin was one delegate who was in favor of greater democracy. George Mason also spoke in favor of the lower classes, saying, "We ought to attend to the rights of every class of the people." He recognized that the largest chamber of the legislature should come from the people, but he also sought to limit its authority. And he said this on May 31st. And you can go to the hot link that I have here, and you can find the text that I have just cited to you. However, by far, the largest group at the convention included those identifying themselves as Federalists. They intensely disliked the idea of popular democracy. They also sought favor for the property class. And so on May 31st, Edmund Randolph, who is a strong Federalist, said the nation's worst problems were caused by the turbulence and follies of democracy. Roger Sherman, on the same day, said the people should have as little to do as may be about the government. You can see here from Sherman's statement that he is very disdainful of the idea of the people being involved in the new government. Elbridge Gerry on September the 17th. Gerry commented that democracy is the worst of all political evils. John Dickinson on August 7th, just as a sort of a bio on John Dickinson. He was one of the wealthiest men in the country. He considered freeholders or property owners as the best guardians of liberty, and the restriction of the right of office holding and voting to them as a necessary defense against the dangerous influence of those multitudes without property and without principle, with which our country, like all others, will in time abound. Uh, Look at his text a little more carefully and see what's on his mind. Uh, he's saying that property owners are not subject to bribe, whereas people who don't have property are more likely to be to sell out, if you will. And so he's very disdainful of the idea of anyone but the nation's property holders having any ability to vote or to hold office. And of course, this was the situation that existed in most of the states. In every state except Pennsylvania, there were property holding rights, property holding requirements, if you will, in order to serve in the legislature as well as in order to vote. Just to give you a sense about that, in some of the southern states, in today's money, you had to be a multimillionaire in order to hold public office, and you had to have significant property in order to vote in some of the southern states. Governor Morris, just to continue to emphasize the point, on August 7th, expressed great disdain for the laboring class, commenting that a national freehold requirement is required to prevent their corruption. And I'm quoting directly from August 7th, give the votes to people who have no property, and they will sell them to the rich. The time is not distant when the country will abound with mechanics and fabricators who will receive the bread from their employers. Will such men be secure and faithful guardians of liberty? He thinks not. Alexander Hamilton, on June 19th, stated, I believe the British government forms the best model the world ever produced. This government has for its object public strength and individual security. All communities divide themselves into the few and the many. The first are the rich and well-born, and the other the mass of the people. The people are turbulent and changing. They seldom judge or determine right. Give therefore to the first class, that is the rich and well-born, a distinct permanent share in the government. They will check the unsteadiness of the second, that is the people. And as they cannot receive any advantage by a change, they therefore will ever maintain good government. So Alexander Hamilton was definitively opposed to the people having much control of the government, much right representation in the government, or participating in the new government. Discussing the mode of selecting the president, Elbridge Gerry objected to direct election of the president by the people on July 25th. He said, and I'm quoting, a popular election in this case is radically vicious. The ignorance of the people would put it in the power of some one set of men dispersed through the Union and acting in concert to delude them into any appointment. He observed that such a society of men existed in the Order of Cincinnati. They are respectable, united, and influential. They will, in fact, elect the chief magistrate in every instance. If the election be referred to the people, his respect for the characters composing the society could not blind him to the danger and impropriety of throwing such a power into their hands. Colonel Mason concurred in his arguments the next day. Okay, just a side note here. We talked about this earlier. The Order of Cincinnati was a group of former officers of the American Revolutionary Army. It was dispersed throughout the states, and that order still exists today. And if you click the hot link that I have here at the bottom, you can go to their website. James Madison, on August 7th, argued that the freeholders of the country would be the safest repositories of Republican liberty. Later in Federalist 10, Madison wrote, democracy is the most vile form of government. Democracies have ever been spectacles of turbulence and contention, have ever been found compatible with personal security or the rights of property, have in general been as short in their lives as they have been violent in their deaths. Here, Madison is mirroring the point I made a few minutes ago. Specifically, that the experience of the world in the period prior to America was one where democracies consistently failed. And of course, as I mentioned last time, Aristotle said that democracy is the worst form of government. The founders were avid readers of political philosophy and consumers of history. And this is the viewpoint that most of the founders had about incorporating democracy into the new form of government. The American Declaration of Independence states, we hold these truths to be self-evident, that all men are created equal, that they are endowed by their creator with certain inalienable rights, that among these are life, liberty, and the pursuit of happiness. And of course, since grade school, you've read the American Declaration of Independence, and these values that are espoused in Jefferson's words in the American Declaration of Independence are greatly important in our society. So we could ask an interesting question here. Did the original Constitution contain the word equal or equality? What do you think? The answer is no, it did not contain the words equal or equality. Why not? Because the founders, the individuals who wrote the Constitution in its original form, were not interested in equality or producing an equal representation for all. They were property holders interested in creating a framework where property holders were protected and their property was protected by the newly established framework. Did the Constitution in its original form, or even now, contain the words life, liberty, or the pursuit of happiness? Again, the answer is no. Why not? Again, the answer is that these members of the Constitutional Convention were not particularly interested in people's lives, their liberty, or the pursuit of happiness. They were interested primarily in protecting their own property. Did the founders consider the notion that all men are equal to be true? I'm following that with 4 question marks. I would argue that only just a very few of the founders thought that all men are equal. What does it mean to say that all men are created equal? How are all men created equal? Are they equal in their property? Obviously, no. Are they equal in their rights? Probably no as well, even in today's America. Okay, so at the Constitutional Convention, there were several plans that were put forth to guide the deliberations, and the Virginia Plan is the most influential of these plans on the final product. The Virginia Plan was proposed early in the convention on May 29th of 1787, and it was the initial, the motivator for the initial discussions of how the new government should be designed. And it's worthwhile to look at its features and to think about the initial and current forms of American government and how they differ from what the proposals were. And so let's click the link that I have here to the Virginia Plan to see what the precise proposal was. Okay, so you can see that there are various texts for the Virginia Plan. Let's read it, significant parts of it. Phrase 1, resolve that the Articles of Confederation ought to be so corrected and enlarged as to accomplish the objects proposed by their institution, namely common defense, security of liberty, and general welfare. 2, resolve that the right of suffrage in the national legislature ought to be proportioned to the quotas of contribution or to the number of free inhabitants, as the one or the other may seem best in different cases. So you can see here in the second statement, the right of suffrage ought to be proportioned to the quotas of contribution. This is an allusion to the idea that people who don't have property aren't contributing much. And so this is an endorsement of the idea that property holders should have the right of suffrage, and that the national legislature should be proportioned to the quotas of contribution or to the number of free inhabitants as the one or the other may seem best. Statement 3, the national legislature ought to consist of 2 branches. 4, that the members of the first branch of the national legislature ought to be elected by the people of the several states every blank, a certain number of years, for the term of blank, a certain number of years, to be the age of years at least, to receive liberal stipends by which they may be compensated for the devotion of their time to public service, to be ineligible to any office established by a particular state or under the authority of the United States, except those peculiarly belonging to the functions of the first branch, during the term of service and for the space of blank after its expiration, to be incapable of reselection for the space of blank after the expiration of their term of service, and to be subject to recall. So here we're seeing a proposal that the delegates to the convention should decide collectively how often the members of the legislature should be voted on, and how long they should serve, and then that they term limits would exist. So they would be excluded from any office for a period of blank after their term expires, and to be incapable of reselection for the space of blank after the expiration of their term of service, and to be subject to recall. So in other words, the founders are proposing term limits as well as the right of recall for the constituents. So this is what the first branch of the national legislature is supposed to look like, and the decisions then are put forth to the convention. Number 5, the members of the second branch of the national legislature ought to be elected by those of the first, out of a proper number of persons nominated by the individual legislatures, to be of blank the age of years, at least to hold their offices for a term sufficient to ensure their independence, to receive liberal stipends by which they may be compensated for the devotion of their time to the public service, and to be ineligible to any office established by a particular state or under the authority of the United States, except those peculiarly belonging to the functions of the second branch during the term of service and for the space of blank after the expiration thereof. So again, to be debated by the convention is how old members of the second branch should be, and how long they are excluded from service after their term ends. Number 6, that each branch ought to possess the right of originating acts, that the national legislature ought to be empowered to enjoy the legislative right vested in Congress by the Confederation, and moreover to legislate in all cases to which the separate states are incompetent, a limit placed on legislation, or in which the harmony of the United States may be interrupted by the exercise of individual legislation, to negative all laws passed by the several states, contravening, in the opinion of the national legislature, the Articles of Union or any treaty subsisting under the authority of the Union, and to call forth the force of the Union against any member of the Union failing to fulfill its duty under the articles thereof. So each branch then would have the right of originating legislation. The national legislature would have a negative on the laws passed in the several states, and the articles of union, of any treaty. They could negative any treaty, and so forth. Okay, finally we get to the executive, that is the presidency. Resolved that a national executive be instituted to be chosen by the national legislature for the term of blank years to receive punctually at stated times a fixed compensation for the services rendered, in which no increase or diminution shall be made so as to affect the magistracy existing at the time of the increase or diminution. To be ineligible a second time, note there, the Virginia plan is providing for a term limit, serve one period of blank years and not be eligible after that. And that besides the general authority to execute the national laws, it ought to enjoy the executive rights vested in Congress by the Confederation. Okay, number 8, resolve that the executive and a convenient number of the national judiciary ought to comprise a council of revision with authority to examine every act of the national legislature before it shall operate, and every act of a particular legislature before a negative thereon shall be final, and that the dissent of the said council shall amount to a rejection unless the act of the national legislature be again passed, or that of a particular legislature be again negative by blank of the members of each branch. So in other words, the veto power is being invested in the chief executive as well as the national judiciary, and veto can be overridden by the national legislature when a certain number of members agree with that. Okay, we won't go on and on and on here, but there's a plan for the national judiciary. There's a plan for admitting new states to the Union, that a Republican government in the territory of each state ought to be guaranteed by the United States, that provision ought to be made for continuance of Congress and their authorities and privileges under a given day, and so forth. So you can see that the Virginia plan is quite detailed in what is provided there. Okay, so let's go back to our lecture. I just wanted to highlight the details of the Virginia plan, and because this is the basis for the initial discussions of the new government. Pertinent to the presidency, note that the president was to be chosen by the legislature and would serve for one term with the length of that term to be decided. So this is what was provided for in the Virginia plan. There will be 2 legislative branches, the first elected by the people, the second chosen by the first branch. There will be a judiciary with judges that serve under good behavior. What does good behavior mean? Well, it means for life, unless you exhibit bad behavior, something that is impeachable, in other words. There would be a council of revision comprised of the executive and some justices to examine all legislation with limited veto authority under the Virginia plan. Okay, the counterbalance, if you will, to the New Jersey plan, to the Virginia plan, was a New Jersey plan. The New Jersey plan proposed a radically different form of government from the Virginia plan. It basically provided for a weak federal government and a weak executive. It was an effort to give primacy to the states. And if you go to the link that I've got here, we'll go there just briefly. We won't read all of it. You will see basically it's in the same format as the Virginia plan was. And I invite you to read the New Jersey plan. We're going to summarize it down below here. So under the New Jersey plan, there would be one chamber of the legislature. It would be unicameral with equal representation across the states, regardless of population. So like with the Articles of Confederation, the idea was that the states would be the predominant figures in the unicameral legislature. Each state would be represented equally in the unicameral legislature. So in other words, it is the states rather than the people who are being represented in the legislative body. The president was to be elected by the legislature to a single term of length to be decided, and could at any time be removed by a majority vote upon the recommendation of the governors of the states. Under the New Jersey plan, the president could consist of a single person or be plural, and that was left undecided. Of course, thinking about the New Jersey plan, the idea of the presidency serving one term of a certain length, and it could be removed upon recommendation of the governors and would consist of either a single person or plural. This is laying out the definition of what would be a really weak chief executive. The idea of a single person versus a plural, the idea of a plural would be that that would be a committee, that the presidency would be a committee, just as had been the case during times when the Articles of Confederation, the Congress was not in session. You had a plural leadership when the Congress was not in session under the Articles of Confederation. You can well imagine that with plural leadership as opposed to singular leadership, you would have a body that is less decisive. A judiciary would be appointed by the president to serve during good behavior. In other words, the president would appoint justices of the Supreme Court, and they would serve for life unless they somehow misbehaved and could get impeached. Okay, Hamilton's plan is often not as much discussed, but it is an important element of what went on at the Constitutional Convention. And this was made on June 18th of 1787. You can click the link there to see the specifics, but I'm going to summarize those. You would have, under Hamilton's plan, a legislature comprised of two chambers. The first with members elected by the people for a term of 3 years, and the second, a Senate with members elected for life by electors chosen by districts within the states. So notice that the members of the Senate will serve for life. What is that like? What is that similar to? Well, it's similar to the House of Lords in Britain. The difference being at the House of Lords in Britain, you are elected, you are chosen for life by birth. If you're a member of the nobility, then you are a member of the House of Lords. What's Hamilton proposing here to replace that nobility? He's suggesting that members of the Senate should be elected for life by electors chosen by districts within the states. So he's saying that each state would have a certain number of electors chosen by district. This is similar to choosing the president by an electoral college. Hamilton's plan called for a strong executive who would serve for life, elected by electors in the same Senate districts. Note that this was not like an electoral college with electors chosen by states, as currently exists now in most. Rather, he is proposing that the executive would be chosen by the district plan, which we'll talk about later. The executive would have an absolute veto over legislation. The executive would have discretion on whether to execute the law, treaty-making power with Senate approval, and with all of the other powers vested under the current Constitution. So Hamilton's plan is calling for a very strong presidency. The judiciary under Hamilton's plan would serve during good behavior, that is for life. and impeachment would have been through the judiciary and not through Congress. Hamilton called for federal supremacy over the states and state laws, just as had the Virginia plan. Okay, unable to decide between the Virginia plan and the New Jersey plan, the Connecticut Compromise was reached, and the delegates assigned a committee under the leadership of Elbridge Gerry to find a resolution to that disagreement between those supporting the Virginia plan and those supporting the New Jersey plan. Gerry's committee came up with a compromise. It was called the Connecticut Compromise, and it gave the lower house popular representation with the upper house representing the states equally. And so that was the original design of the legislature, with the lower house represented by the people and the upper house representing states equally. And the state legislatures would appoint the members of the upper house rather than have them be elected. The Connecticut Compromise was reported out of committee on June 29th, and it resolved the issues of legislative representation, firmly establishing the idea that states should be represented apart from the people. While not pertaining to the presidency directly, the creation of a Senate independent of popular representation with power to approve nominations, treaties, and so forth had implications for presidential power. It was a check, if you will, on presidential power. Okay, there was also the question of representation of the different states, and in particular the question of representation for southern states, where the population consisted of about half of slaves, arose on June the 11th. This was a very thorny issue. It was decided after some debate that slaves would count as 3/5 of a person, despite the fact that southern states thought of their slaves as property, like cows or chickens or pigs, rather than persons. The decision that was made here, called the 3/5 Compromise, had implications for representation in the House of Representatives, as well as for how the president was selected. Direct popular election was rejected in favor of an electoral college, which designated electors based on the total number of House and Senate members from each state. This was discussed on July 19th, and see especially James Madison's words on that date. And so we're going to go to July 19th and look for James Madison, and we will we'll read what Madison had to say about this issue. Okay. So here's Madison. He says, if it be a fundamental principle of free government that the legislative, executive, and judiciary powers should be separately exercised, it is equally so that they be independently exercised. There is the same and perhaps greater reason why the executive should be independent of the legislature than why a judiciary should. The coalition of the two former powers would be more immediately and certainly dangerous to public liberty. It is essential then that the appointment of the executive should either be drawn from some source or held by some tenure that will give him a free agency with regard to the legislature. This could not be if he was to be appointable from time to time by the legislature. It was not clear that an appointment in the first instance, even with an ineligibility afterward, would not establish an improper connection between the two departments. Certainly it was that the appointment would be attended with intrigues and contentions that ought not to be necessarily admitted. He was disposed for these reasons to refer to the appointment to some other source. The people at large was, in his opinion, the fittest in itself. It would be as likely as any that could be devised that produce an executive magistrate of distinguished character. The people generally could only know and vote for some citizen whose merits had rendered him an object of general attention and esteem. And the next few sentences is what is important here. Madison said, there was one difficulty, however, of a serious nature, attending an immediate choice by the people. The right of suffrage was much more diffusive in the northern than the southern states. He's alluding to slaves being thought of as property, and the latter could have no influence in the election on the score of the Negroes. The substitution of electors obviated this difficulty and seemed on the whole to be liable to the fewest objections. And so you can see here that the choice of an electoral college for selecting the president was deeply rooted, if you will, in the question of slavery in the South and the question of race in the South. Okay, so we have an electoral college then that is rooted in slavery. Slavery is the reason why we have an electoral college today. And I'm going to give you some recommended reading on this. It's a New York Times article that was published on August the 3rd, and it gives the extent to which the electoral college is rooted in racism and white supremacy and so forth. Note that Hamilton's plan called for direct popular election of presidents through districts within the states. Note that that's also different from what we have today. Hamilton's plan is the so-called district plan. The idea is that there would be districts in the state based on population within the districts, and that those districts would then cast ballots. They would choose electors. Each district would choose an elector for the state, and that elector would be bound to vote in the way that the district within the state had designated them to vote. Ratification of the new document occurred not in a public referendum. People didn't go out and vote on the final document. Rather, ratification conventions were held in each state with delegates chosen from those holding the franchise in the state. In other words, property holders were designated to attend the ratification convention. So you have the same biases at the ratification conventions in each state as you had in the Constitutional Convention. Charles Beard estimates that about 3/4 of the adult white male population did not participate in selecting delegates to ratification conventions. He also estimates that no more than about 1/6 of the adult white male population actually participated in ratification of the final document. Beard also notes that leaders at the ratification conventions generally represented the same economic groups as the members of the Philadelphia Convention. And in a large number of instances, they were also directly and personally interested in the outcome of their efforts. And so the Constitution was not created by we the people, as is stated in the preamble of the Constitution, but rather was created by property holders in early America. A very public ratification debate occurred over a period of about 2 years. The last state that ratified the Constitution in May of 1790 was Rhode Island. This is about a year after George Washington was first elected to the presidency. Newspapers, pamphlets, which was a popular mode of news dissemination in those times, public discussions, public debates, all of these things surrounded the ratification of the document. Note that those who were at the convention but did not sign the document worked very diligently against ratification. Among those who were participants at the convention but didn't sign the document and who worked against ratification were prominently Edmund Randolph, George Mason, Elbridge Gerry. Patrick Henry, of course, was not at the convention, but he worked diligently against the document. Sam Adams, also not at the convention, working hard against the document. And you can go to the link that I have here for a timeline on ratification of the final document. Thomas Jefferson was still in France during this period, but he let it be known through letters to James Madison that he strongly opposed the final document that emerged from the Constitutional Convention. As expressed by Beard, quoting directly from Beard, he says, "No one can pore for weeks over the letters, newspapers, and pamphlets of the years 1787 to 1789 without coming to the conclusion that there was deep-seated conflict between a popular party based on paper money and agrarian interest and a conservative party centered in towns and resting on financial, mercantile, and personal property interests generally." So although there were no political parties at this time, partisan polarization had emerged in the ratification period. Who are the emerging political parties? You have one political party rooted in democracy, rooted in the notion of there should be paper money and agrarian interest, and you have another political party centered in the towns and resting on financial, mercantile, and personal property interests. So you have a conflict between greater representation for the common man on the one hand and representation by the property class on the other hand. The day-by-day discussion of the presidency at the Constitutional Convention, coming from Madison's notes. Here's a listing of the dates on which the presidency was discussed at Madison's notes. And I invite you to, I know there are a lot of links here, but I invite you to visit these links in order to see the back and forth that went on at the convention concerning the design of the presidency. Let's just look at the discussion on two of those dates, June 1st and June 2nd. By this time, the participants had looked at both the Virginia plan and the New Jersey plan. So let's go to June 1st. Okay, so starting here, Mr. Pinckney was for a vigorous executive, but was afraid the executive powers of the existing Congress might extend to peace and war, etc., which would render the executive a monarchy of the worst kind, to wit, an elected one. Mr. Wilson moved that the executive consist of a single person. Mr. Pinckney seconded the motion so as to read that a national executive to consist of a single person be instituted. A considerable pause ensued, and the chairman asked if he should put the question. Dr. Franklin observed that it was a point of great importance and wished that the gentlemen would deliver their sentiments on it before the question was put. So Mr. Franklin is arguing for further debate. Mr. Rutledge adverted to the shyness of gentlemen on this and other subjects. He said it looked as if they supposed themselves precluded by having frankly disclosed their opinions from afterwards changing them, which he did not take to be all the case. He said he was for vesting the executive power in a single person, though he was not for giving him the power of war and peace. A single man would feel the greatest responsibility and administer the public affairs best. Mr. Sherman said he considered the executive magistracy as nothing more than an institution for carrying the will of the legislature into effect, that the person or persons ought to be appointed by and accountable to the legislature only, which was the depository of the supreme will of the society, as they were the best judges of the business which ought to be done by the executive department. Okay, so we'll stop there. You can see a vigorous debate is going on this day as to the nature of the presidency. Let's go to June 2nd and see more of the same. Okay, Mr. Wilson made the following motion to be substituted for the mode proposed by Mr. Randolph's resolution, that the executive magistracy shall be elected in the following manner: that the states be divided into blank districts, and that the persons qualified to vote in each district for members of the first branch of the national legislature elect blank members for their respective districts to be electors for the executive magistracy, that the said electors of the executive magistracy meet at blank, and they or any blank of them so met shall proceed to elect by ballot, but not out of their own body, blank person, blank in whom the executive authority of the national government shall be vested. So Mr. Randolph has proposed he's proposed one plan. Mr. Wilson is suggesting that the Electoral College should use the district plan. Mr. Wilson repeated his arguments in favor of election without the intervention of the states. He supposed too that this mode would produce more confidence among the people in the first magistrate than an election by the national legislature. And so this continues on a vigorous discussion of how the president should be selected on this date. Reading the notes shows that there were two factions at the convention: those favoring a strong executive versus those favoring a weak executive. Following is a table that summarizes the decisions that were made and where each faction, strong versus weak executive, stood. Again, this table is repeated in the textbook. Features of the executive: the relation to Congress. Those advocating a weak executive wanted the president to just execute the will of Congress. Those favoring a strong executive, the president would have powers independent of Congress. And the final decision by the convention, powers independent of Congress with checks and balances. The number that constituted the executive. The weak executive group wanted a plural executive, that is a committee to be the executive, or a single individual checked by council. The strong executive group wanted a single individual with no council or only an advisory one. The decision by the convention was that a single individual would be chosen with Senate advisory on some matters. The method of choosing the president: the weak executive group wanted the president to be chosen by Congress. The strong executive group wanted the president to be chosen by means other than popular selection. The final decision by the convention was an electoral college. A key point here on that electoral college was it was left up to the states to decide how the electors would be chosen. Note there was a vigorous discussion at the convention on whether Hamilton's district plan should be used or whether or not it should be left up to the states, and it was decided to punt and leave it up to the states on the selection of the president. How long would the president serve? Weak executive group wanted the president to serve for a limited term that was not renewable. So in other words, there was a term limit on the president. The strong executive wanted there to be no limitation on the president's length of term. And of course, the extreme of that was Hamilton's plan, which provided that the president would serve during good behavior. In other words, he would be serving for life as long as he behaved himself. What was the decision by the convention? The presidents would be elected for a period of 4 years, but he could serve an unlimited number of terms. The current limitation that we have came by constitutional amendment, ratified in 1952, I believe. How could the president be removed? The weak executive group wanted Congress to be able to remove the president during his term of office for any reason whatsoever. The strong executive wanted the president to be removable only for definite enumerated reasons after impeachment and conviction by judicial body or Congress. And the final decision by the convention was that the president could be removed for treason, bribery, high crimes and misdemeanor by impeachment by a majority of the House of Representatives and conviction by 2/3 of the Senate. The scope and source of executive powers, the weak executive group wanted the powers of the president to be limited, and the powers would be strictly those that are delegated by Congress. The strong executive group wanted the president to have broad powers from the Constitution, not subject to congressional influence. The final decision by the convention was that the president would have broad powers delegated by the Constitution. The appointment, foreign policy, and war powers, the weak executive would have none of these powers. It would be purely a province of Congress to appoint, to hold foreign policy, and to conduct war. The strong executive group wanted to appoint diplomatic and judicial officials and participate in foreign policy and war-making powers. The final decision by the convention was that the executive would appoint judicial officials with the consent of the Senate, that he would share foreign policy and war-making power with Congress. The Senate ratifies treaties negotiated by the president, and with regard to war-making, only Congress has the authority to declare war, but war is conducted by the president. Finally, the veto power, the weak executive group wanted the president to have no veto power. The strong executive group wanted the president to have veto power over legislation passed by Congress, exercised either alone or with the judiciary. Finally, the final decision by the convention was that the president would have a qualified veto that may be overridden by 2/3 vote of the House and Senate. Okay, you can see that we have reached the end of the prepared lecture materials. And so I'll summarize. We have, during this session, laid out the important features of the ratification convention. We've talked about the different plans, including the Virginia plan, the New Jersey plan, Hamilton's plan, the Connecticut Compromise, the 3/5 Compromise, and the way in which we arrived at the design of the current presidency. I would like you to take from this discussion general understanding that it was not consensual as to how the president would be elected, nor was it consensual what powers the president would have. And so there was a vigorous debate and discussion at the Constitutional Convention that is evidenced in Madison's notes to the Constitutional Convention. We will, in the next session, talk about specifics. We're going to tie presidential powers, presidential formal powers, into what is said in the Constitution, and what are the limits on presidential power deriving from the Constitution. And so in the next session, we're going to lay out more specifically what are the president's formal powers. Let me just be clear. Formal powers are those powers that arise for the president as a result of the Constitution and the laws of the United States. And so we'll lay out those formal powers that derive from the Constitution during the next session. I wish you and bid you a farewell, and hope that you have enjoyed this lecture, and that you will consume these materials in good faith. Be happy and be healthy and be well. Bye.